The next segment we're going to talk about is a short segment about financial matters that come up in custody and visitation cases. So first, let's talk about child support. Child support is calculated by the South Carolina DSS guidelines. You can find them online on the DSS child support website. And they also take into consideration things like how much one parent is paying for health care, how many kids are in the home, and the cost of daycare. You should know that when you're negotiating or mediating a case, that the number of days that the kids stay with one parent can determine the outcome of what the child support is. So if that number of overnights goes over a certain number, then the child support calculation considers it more of a shared custody situation just for the purposes of child support, which will affect that number. So keep that in mind. Also, just a handy tip is to figure out when and how often the non-custodial parent is paid. That can just make the process a little bit smoother when you go through the child support office at your local courthouse. So I always ask if they're paid weekly or bi-weekly or bi-monthly or monthly, just to help align what the court orders with what actually works well.
I try not to take them at face value. I generally ask for backup documentation. You can get that. You can ask nicely, and sometimes they'll provide it to you, and they should with their financial declaration. But if they don't, then you could always ask for that information through discovery.
That's a great tip. Also, to decide whether you want wage withholding, I generally do recommend this to my clients. Wage withholding is where the child support office at the courthouse can take the money through the non-custodial parent's employer, so it goes directly from that person's paycheck. Generally a way to make sure it actually happens. Now, of course, if the non-custodial parent changes jobs, there's a little bit of paperwork goes on, and sometimes they might quit their job. So it's not perfect, but it does usually help to make sure that child support is paid on time. I find that some non-custodial parents don't want their employers to know that they're paying child support, so sometimes we come to agreements such as we're going to start with the non-custodial parent paying it directly to the client, but if the non-custodial parent is a certain amount of days late or is late a certain amount of times, that the custodial parent can then file an affidavit so that it starts going through the child support office and starts having wage withdrawal. But if you come up with any sort of agreement like that, you really need to spell it out to make sure that it is possible for the custodial parent to follow through with that if necessary. Also in the order, you need to specifically state the amount, how often it's paid, whether it's by wage withholding, whether it's through the clerk of court's office, and if it is, that the payer is the person responsible for the 5% court costs. So for example, you also want to say how much that is. So for example, you might say dad pays $100 a week plus a 5% court costs for a total of $105 per week.
I want to add two things. If your client elects not to take payment through the clerk of court and it's just coming directly from the payer, I encourage them to have some way to document that that was or was not paid. So I don't know if that means keeping a journal or doing receipts or however they want to do that, but it's good to have some kind of backup documentation. Second, sometimes if the individual, for example, if it were a mother or a victim who their child was born outside of marriage and they're the de facto custodian or the presumed custodian, and they don't want to bring litigation and they might be receiving some sort of public benefit, they then could possibly have DSS bring a child support enforcement action, and then the burden wouldn't be on them to initiate that process in family court. So as a separate standalone action.
That's a great point, and there are a lot of strategic reasons that sometimes people may choose to go through child support, DSS child support, instead of doing the family court case if perhaps they're getting along and it's going to cause more problems.
Sure.
If they bring an action.
Particularly for domestic violence victims.
I've included just some sources here. Traxlers is some software that we use at Legal Services. Also, the DSS Child Support website has a very user-friendly calculator that I recommend using. And Another question you should ask your client is whether child support was previously ordered in their case. So, for example, what Lindsay was explaining about, they may have had a child support case brought through DSS because of certain benefits the custodial parent received, or just because they needed to establish child support. If it was already established, you and your client need to talk about, do we want to just carry that over and incorporate that amount and calculation in this case, or does it need to be recalculated? And that'll probably depend on whether the parties have changed jobs, had increases in income, had more children, that kind of thing. Also, if it was previously established by DSS child support, you need to inform them when you bring this action and are asking for a change in the child support.
And just keeping in mind that child support can always be modified. I mean, most things pertaining to child custody or visitation or support can be modified during that child's minority.
Health insurance is something else you're going to need to talk about with your client and eventually work out or ask the judge to decide. The child support calculation does include the cost of health insurance, so it does give some credit to that parent who is providing the health insurance. Another thing you need to talk about is who's going to pay the uncovered expenses. Even with my clients who are on Medicaid, I recommend that we do make some provision for this because we never know what certain benefits are going to cover in the future. A couple common ways to do it. Sometimes the parties might say, we'll evenly divide all uncovered medical expenses. Or there's also a way to do it, the standard way is through the child support guidelines, is the custodial parent pays the first $250 per year of uncovered expenses, and then the rest of the expenses are divided along the percentages. And so when I say percentage, I mean when you do the child support calculation, it shows percentages of how their income compares to each other. So it might say 55-45. If dad's 55, mom's 45, then whoever has custody will pay the first $250 per year of uncovered medical expenses. Then dad will pay the remaining 55% of the remaining costs, and mom will pay 45% of the remaining costs. And another thing I recommend is to also include dental, pharmaceutical, therapeutic, all of those other terms to make sure you incorporate the other needs the child might have besides simple medical needs. And just a quick heads up about some tax benefits. There are some tax benefits that are transferable. However, the Earned Income Tax Care Credit can only be taken by the parent who has the child primarily or for the most of the time. So the parents should not try to make any deals about who gets to take that Earned Income Tax Credit. It's an IRS rule. It's whoever gets the kids the most often. Now, the other two benefits that usually go to the custodial parent are the dependent exemption deduction and the child tax credit. The IRS usually assumes that the person who has custody will get those benefits. However, in some cases, it makes sense for the other parent to sometimes claim the child. I put the number of the form in the slide. This form is the form that allows the transfer of the right to take that benefit. If the divorce was during or after 2009, you should get the custodial parent to sign that form. And I believe you can have them elect up to 3 years or so that they can transfer that right to the non-custodial parent.
In some cases, because sometimes I work with low-income clients, sometimes they're not working. So if the victim is not working and so claiming if there were some reason that claiming the tax benefit, this comes up a lot for some of my undocumented victims who can't legally work in the United States, we have been able to work out an agreement where the person who is able to claim the exemption would then pay a percentage of that to the custodial parent because that person is the parent primarily caring for the child. So there is flexibility, I think, in some cases if you have unique circumstances to think outside the box.
Absolutely. Also, if this is part of a divorce case, you should just know that there is some potential relief available for victims of domestic violence called innocent spouse relief and injured spouse relief. That's a little too specific for us to go into all of that, but it could apply in your case if you're doing a divorce and your client is the victim of domestic violence. And lastly, we're going to talk about attorney's fees. The court really determines whether somebody gets them, and if so, how much of those attorney's fees are going to be paid. So I do recommend that the attorney keep very careful notes and have an updated affidavit when they go to court to ask for those fees. I've also put the statutes on the slide so you can read those.
And for Leslie and many of our clients are low-income clients, and so attorney's fees isn't something that really comes up that often, but if it were to come up, there are two governing cases in South Carolina that you should definitely read if you're thinking about attorney's fees. Those are EDM versus TAM, and then Glasscock versus Glasscock, and they lay out factors that the court has to consider before they award attorney's fees, and one of them, I'm not going to go through all the considerations, but one of the considerations is ability to pay. So what that does, I think in some of our cases that's helpful. Our clients aren't able to be, it can't be used really as a tactic to bully them to agree to something that wouldn't be in their best interest or the child's best interest.
That's it for our money segment. Stay tuned and we'll talk more about the process of filing.